The Earth keeps records. In the layers of sediment and rock, in the chemical signatures of minerals, in the physical properties of soil samples taken from specific locations, the Earth records where things were, when they were there, and what was happening at the time. This is what geologists read. It is a science of enormous precision, and like all sciences of enormous precision, it is a science where getting something wrong has consequences that precision was supposed to prevent. Dr. Samuel Cato was a forensic geologist. He had spent 26 years applying geological science to legal cases, determining where soil and rock samples came from, whether physical evidence was consistent with claimed locations, whether the Earth itself supported or contradicted a story that someone was telling. In 2010, he was convicted of perverting the course of justice. The allegation was that he had knowingly provided a false geological analysis in a murder trial, that he had testified that a soil sample found on a defendant's clothing was consistent with the murder location when, in fact, it was not. Samuel had not done this. He had made an error, a genuine, professionally embarrassing, consequential error in the identification of a mineral present in the soil sample. But it was an error, not a lie. And when a geological expert's error becomes the subject of a criminal prosecution, the difference between those two things matters enormously. He spent 4 years in a Canadian federal prison before a reanalysis of the original sample, conducted by a team of 3 geologists using techniques that had been developed after the original analysis, confirmed that Samuel's error had been genuine and that the sample itself was ambiguous in ways that the original prosecution had not disclosed. This is the story of a geologist, a soil sample, and the question of where the line falls between professional error and criminal conduct in the most technically complex fields of expert testimony. Samuel Cato had grown up in Kampala, Uganda, the son of a university geography professor and a primary school teacher. He had come to his love of geology through his father's bookshelves, specifically through a book about the geology of the East African Rift Valley that he had read at 12, and that had given him the first clear sense of something he wanted to spend his life understanding. He had studied geology at Makerere University in Kampala, then completed a doctorate at the University of Toronto, where he had stayed, attracted by the breadth of geological work in Canada, and by a country that seemed, to a young Ugandan scientist in the 1980s, to offer possibilities that were worth building a life around. He had become a Canadian citizen in 1992. He had built a career that moved between academic research and forensic consultancy, the two feeding each other, as they often do in applied sciences. His forensic work had begun in 1994, when the Royal Canadian Mounted Police had engaged him to analyze soil evidence in a kidnapping case. He had done it well. More cases had followed. By 2010, he had provided expert analysis in 47 legal cases across Canada. He had been qualified as an expert witness in 7 different courts. His methodology had been challenged in several cases and had, in each instance, been upheld. He was regarded by his peers as one of the most reliable forensic geology practitioners in the country. The murder case that changed everything was the trial of a man named Peter Gauthier, charged with killing his business partner in rural Ontario. The Crown's theory was that Gauthier had committed the murder at a specific field location and disposed of the body before reporting his partner missing. The victim was found 2 weeks later. Samuel had been engaged to analyze soil samples from Gauthier's work boots. His analysis had found that the soil on the boots was, in his professional opinion, consistent with the field location identified by the prosecution. Gauthier was convicted. Then Gauthier's appeal solicitor found something. The specific error that Samuel had made in the Gauthier case involved the identification of a mineral called chlorite. Chlorite is a common mineral found in many geological environments. It is, in itself, not a marker of a specific location. Its diagnostic value in forensic geology comes from the specific type of chlorite present, its crystal structure, and its association with other minerals in the assemblage. Samuel had identified the chlorite in the boot sample as clinoclore, a specific variety associated with the metamorphic geology of the Ontario field location the prosecution had identified. His analysis had relied on optical microscopy, which was the standard method in 2008 when the analysis was conducted. Gauthier's appeal solicitor had engaged a second geologist to review Samuel's work. The second geologist, Dr. Andrea Patel, a specialist in mineralogy with access to X-ray diffraction analysis that had not been part of Samuel's original methodology, had found that the chlorite in the sample was not clinoclore but kamacite, a different variety associated with sedimentary rather than metamorphic environments. This distinction mattered because kamacite was present in the area, but not specifically at the prosecution's identified field location. The field location had metamorphic chlorite. The area around it, a much wider area, had sedimentary chlorite. The soil on Gautier's boots was consistent with the wider area, not specifically with the murder site. This did not prove Gautier's innocence, but it undermined the specific claim that the soil on his boots connected him to that specific location. The more serious question, the question that led to Samuel's prosecution, was whether Samuel had known about the difference between clinoclore and kamacite and had deliberately misidentified the sample. The prosecution's theory was that Samuel had pressured to provide analysis that supported the Crown's case, and had done so by misidentifying the mineral in a way that served the prosecution's theory. Samuel said he had made a genuine error. That optical microscopy, while a valid and established method, had limitations in distinguishing between chlorite varieties that X-ray diffraction did not have. That he had identified the mineral to the best of his ability with the tools he had used. That he had not known the identification was wrong. The prosecution did not believe him, or decided not to. The trial of Samuel Cato opened in Toronto in March 2010. It lasted 4 weeks. The prosecution's case rested on 2 arguments. First, that Samuel's error was not a reasonable professional error, but a deliberate misidentification. That a geologist of his experience and expertise would not have confused clinoclore and kamacite using optical microscopy, and that the error therefore implied intent. Second, that Samuel had been under pressure to provide analysis that supported the Crown's case, and had done so by providing an analysis he knew to be wrong. The second argument relied primarily on testimony from a Crown prosecutor who had worked with Samuel on an earlier case, and who claimed that Samuel had, in a private conversation, indicated a desire to maintain his relationship with the Crown as a source of forensic work. The prosecutor characterized this as suggesting that Samuel was motivated to please the Crown rather than to report objectively. Samuel denied this characterization vigorously. He said the conversation had been about scheduling and workload, not about analytical objectivity. The defense brought in 2 forensic geologists who testified that the clinoclore-kamacite distinction under optical microscopy was a known challenge in the field, that even experienced practitioners made this error, and that the introduction of X-ray diffraction analysis to forensic geology work was precisely because of this limitation. They testified that Samuel's error was consistent with the limitations of his methodology and was not evidence of deliberate misidentification. The prosecution's geological expert disagreed. He said that a geologist of Samuel's experience should have sought XRD confirmation before providing definitive analysis in a murder trial. He said that failing to do so, given the importance of the evidence, was grossly negligent at minimum and potentially deliberate. The jury deliberated for 7 days. The distinction between error and deliberate falsification, in a domain most jurors had never encountered, was one of the most technically difficult assessments any jury had been asked to make. They found Samuel Cato guilty of perverting the course of justice. He was sentenced to 5 years. He was 53 years old. He had spent 26 years trying to ensure that the Earth's evidence was read correctly. Now he was in prison for reading it incorrectly once. Samuel entered the Joyceville Institution in Ontario in April 2010. He was a scientist in a federal prison, a specific kind of displacement that is both practical and philosophical. He was assigned, eventually, to work in the prison's maintenance department. The work was physical and required no geological knowledge. He did it. He found, in the discipline of physical work, a way to stop his mind from cycling through the same analysis, the sample, the mineral, the error, that it had been running since 2009. His wife, Susan, visited every fortnight. She was a retired schoolteacher. She brought him books. Specifically, she brought him the latest geological journals, because she understood that the work was who he was, and that cutting him off from it would be a different kind of imprisonment. He read the journals. In 2011, he read a paper published in the Journal of Forensic Sciences that specifically addressed the challenge of chlorite variety identification under optical microscopy. The paper documented 17 cases across North America in which clinoclore and kamacite had been confused under optical microscopy by experienced practitioners. It recommended that XRD analysis become standard practice in forensic geology for any case involving chlorite identification. He read the paper 3 times. Then he wrote to his solicitor. He said, This paper documents exactly what happened to me. Experienced geologists confusing clinoclore and camosite under optical microscopy. This was a known issue in the field. It was not a unique failure. It was not deliberate. It is documented as a professional challenge that the field has now responded to by recommending XRD. His solicitor read the paper. Then he began building the appeal. What made the appeal strong was not just the journal paper. It was what the paper led the solicitor to look for and find in the original Crown disclosure. The prosecution had access, before Samuel's trial, to a technical memorandum from the Ontario Centre of Forensic Sciences, noting the limitations of optical microscopy for chlorite identification. That memorandum had not been disclosed to Samuel's defense team. It was a Brady violation, or rather, its Canadian equivalent. Material evidence relevant to Samuel's defense had not been disclosed. The appeal was heard by the Ontario Court of Appeal in November 2013. Samuel had been released on bail in September 2013 pending the hearing, having served 3.5 years. The appeal rested on two grounds. The first was the non-disclosure of the Ontario Centre of Forensic Sciences memorandum, which had been in the Crown's possession before the trial, and which directly addressed the scientific limitations of optical microscopy for chlorite identification. The second was the new scientific evidence, the Journal of Forensic Sciences paper, and an expert report from a team of 3 senior forensic geologists who had reanalyzed the original sample using XRD and confirmed Dr. Patel's finding that the chlorite was camosite, while also documenting the specific optical microscopy ambiguities that made the original misidentification professionally understandable rather than professionally indefensible. The Crown, reviewing the two grounds, acknowledged that the non-disclosure of the technical memorandum was a serious procedural failure. They did not, initially, concede that Samuel's error had been genuine rather than deliberate, but they acknowledged that the combination of the non-disclosed memorandum and the new scientific evidence created a situation in which the conviction could not be maintained. The Court of Appeal quashed the conviction in December 2013. The court found that the non-disclosure alone was sufficient to render the conviction unsafe. The court also noted in its judgment that the scientific evidence now available suggested that the original prosecution had not adequately accounted for the known limitations of optical microscopy in distinguishing chlorite varieties. The court did not find that Samuel was innocent of error. It found that the conviction could not stand. Samuel Cato's reaction to the quashing was, by his own account, quiet. He had been expecting it. The grounds were strong, his solicitor had been confident, but the expectation of a result and the receiving of it are different things. He sat in the courtroom and heard the judgment and said nothing for a long time. Then he said to his solicitor, "I still got it wrong." His solicitor said, "Yes." And the system handled that wrong in a way that made it much worse. Samuel said, "That is two different things." His solicitor said, "Yes. That is the point." Samuel Cato did not return to forensic work. He returned to academic geology, specifically to a research position at the University of Toronto studying the geochemistry of East African lakes, which had been his original doctoral interest before forensic work had drawn him in a different direction. He says the return to pure research was not a retreat, but a recalibration. He had spent 26 years in forensic work and had been, until the Gautier case, very good at it. The error in that case had been real. The prosecution of that error had been wrong. Both things were true, and he had spent years learning to hold both. The Journal of Forensic Sciences paper that had helped him build his appeal became, in the years following, a significant document in the reform of forensic geology practice in Canada. The Ontario Centre of Forensic Sciences updated its protocols in 2015 to require XRD analysis for any case involving chlorite identification. Several other provincial forensic services followed. Samuel was cited in 2 of those protocol documents as the case that had made the reform necessary. He received compensation from the Canadian government. He filed civil claims that were settled in 2015. Peter Gautier, the defendant whose conviction had been partly based on Samuel's analysis, was granted a retrial. At the retrial, the soil evidence was presented with the XRD findings and its ambiguity properly acknowledged. Gautier was convicted again on other evidence that did not depend on the soil analysis. The murder conviction was, in the end, upheld, but the conviction was now based on evidence that had been properly presented. Samuel says this matters to him, that he had worried, during his imprisonment, that his error had contributed to the wrongful conviction of Gautier, that both of them had been wronged by the same misidentification. Learning that Gautier had been convicted on other grounds was, he says, a specific relief he had not known he needed until he felt it. Samuel Cato is 67 years old. He retired from the University of Toronto in 2022. He lives in Toronto with Susan. They have 3 grandchildren. He spends his retirement writing a memoir about forensic geology and its legal implications that he describes as the most difficult writing project he has ever undertaken, because it requires him to be simultaneously the scientist, the defendant, and the person looking back at both. He has said, publicly and on several occasions, that he made a genuine error in the Gautier case. He has never suggested otherwise. He says the error had consequences for Gautier's appeal, for the integrity of the original trial, for the use of forensic geology evidence in criminal proceedings. He takes responsibility for those consequences in the way that a scientist takes responsibility for wrong conclusions, by acknowledging the error, understanding why it was made, and ensuring the field does better. What he does not accept, and what the Court of Appeal affirmed he was right not to accept, is that the error constituted criminal conduct, that the distance between a professional misidentification, made in good faith with the best available methodology, and deliberate corruption of legal proceedings, was so small as to be prosecutable, that the failure to disclose material evidence about the known limitations of his methodology was an adequate basis for a criminal conviction. He says, I got it wrong. The system's response to that was also wrong. I had to fight to establish the second point without losing sight of the first. That balance, holding your own error alongside the system's error, is one of the harder things I have done. He says, the earth keeps records. Geology is the science of reading those records carefully, with the right tools, at the right resolution. The legal system had a record of what happened in that case. It did not read it carefully enough, and I did not use the right tool. He pauses. He says, the difference is that the legal system's failure produced a criminal conviction. Mine produced an embarrassing retrial. The proportionality of those outcomes was not adequate. He goes back to his memoir. The writing is slow. He checks each sentence several times before he lets it stand. He has learned, the hard way, the cost of getting things wrong in the single moment when precision is everything. He says, that is what I will carry from this. The understanding that precision is always everything. Not sometimes. Always. He writes the next sentence. He checks it. He lets it stand.